Today I will be talking to you about intellectual property, copyright, trademark, and also an organization called WIPO, which stands for World Intellectual Property Organization. And I will also be referring to a court case that is very popular called A&M Records versus Napster. Okay, so first I want to talk about intellectual property. Intellectual property is a work or invention that is the result of a creativity such as manuscript or a design to which one may apply for a patent, copyright, or trademark. Okay, so WPO, which stands for World Intellectual Property Organization, was created to encourage creative activity to promote the protection of intellectual property throughout the world. WIPO pretty much offers services for protecting intellectual property across the borders and for resolving intellectual property disputes outside the courts. Okay, so A&M Records, which was founded in 1962 by Herb Alpert and Jerry Moss, and Napster, which is now known as Rhapsody, it's popular now. It actually became popular in 2014. That's whenever they changed the name in 2014. Napster was actually created on December 3rd, 2001. Pretty much during this court case, there was a lot of controversy about Napster having people download music that wasn't legal. So pretty much this court case put it into any speculations that such service could facilitate copyright infringements, but still shielded themselves for liability due to the fact that it is or was the users that chose to share the illegal copies of the protected works, which is the music. Napster pretty much is a music sharing website. It's based in California. Well, was based in California. It had over 70 million users. It was one of the biggest and most popular free music download sites, which now it's Rhapsody. So the numbers have increased. It was pretty much a peer-to-peer file sharing program that allowed users to make MP3 audio files available on their users' own computers or different devices. So pretty much the problem was major record companies took issue that the large-scale distribution of their music for free, and they end up suing Napster for the direct contributory, meaning operated by means of funds into which people would pay. So they were sued for infringement. Napster users could then download these files from their own computers. Basically, Napster's users could make exact copies of the music for their MP3 files and transfer them throughout the computer and different internet. Eventually, Napster tried to settle by paying the music companies $1 billion. If the companies would license all of their music to Napster, so pretty much like if they would just kind of combine them and join them. But the companies refused. July 2001, Napster actually shut itself down to do some reconstruction to figure out how it would be complied to the copyrighted music. Napster knew that the infringement situation was going to fail and reduce the people trying to download music. So eventually that's whenever they changed to Rap. Court case that's kind of current would be Sony BMG versus Tenenbaum. Joel Tenenbaum illegally downloaded and was distributing music for like a couple of years. Pretty much Sony decided to sue him for all the damages. And he actually was, I think he downloaded 30 songs. So for each song, the company was supposed to be rewarded $675,000. From 1999 to 2007, he used the peer networks just like Napster to download the music and distribute them. In court, Joel actually lied about the activities that he was doing. About all of the different court cases relevant to this topic was very informative. I learned some new things that I did not know, and I'm glad that we talked about this topic. So yes, thank you for listening.